14A District Court for County of Washington State District is now back in session. The Honorable Judge Jacob accepts the presiding. You may be seated.
We're back on the record, and right away, you can feel the gravity in this courtroom. This isn't a routine bond adjustment. This is a full-scale collision between the defense asking for freedom and the prosecution demanding total denial of bond. And when you hear the charges involved, quobus crimes but criminal sexual conduct in the first degree, multiple alleged victims, grooming behavior inside a church setting, this is the kind of hearing that can redefine the entire trajectory of a case. Judge Simpson immediately frames this as a legal standards battle. This isn't about emotions, it's about whether the law allows bond to be denied and under what conditions. But here's the tension. When allegations involve predatory behavior and potential life sentences, the stakes skyrocket. If bond is reduced and something happens, that's catastrophic. If bond is denied and the defendant is later acquitted, that's months, possibly years, of liberty lost. And pay attention to the word grooming. The judge isn't throwing that around casually. That signals he's already seeing a pattern in the allegations, not isolated incidents. That matters. A pattern changes how a court evaluates danger and flight risk. So the big question forming in this courtroom, is this a case where bond is a constitutional right or a risk the court simply cannot afford to take?
We're back on the record in the case of the People's State of Michigan versus Zachary Radcliffe. In this case, there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking, to the contrary, that his bond be effective, well, not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically, with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree, armed robbery, kidnapping with the intent to extort money or other valuable thing. Thereby, if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person, or what one may say, a danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents.
When Judge Simpson uses the phrase grooming and predatory behavior, that's not accidental language. That's loaded. Grooming implies intentional preparation, systematic manipulation over time. It suggests planning, access, authority, and psychological leverage. Notice what he references next. The defendant's position within the church and access to youth. That's critical legally. Courts evaluate not just the alleged act, but the power dynamic. Authority figures, teachers, clergy, coaches are held to a different level of scrutiny because access itself becomes a tool. Now here's the deeper legal implication. If the court believes the alleged conduct was facilitated by position and trust, that strengthens the prosecution's argument that the defendant poses a continued danger to the community. And It's not just about what allegedly happened, it's about whether the conditions that allowed it still exist. And here's something to consider. If someone is accused of exploiting authority to silence victims, does that make them more dangerous pre-trial than someone accused of a one-time violent act? That's the psychological layer the judge is dissecting right now. This is no longer just about bond. This is about pattern, power, and prevention.
Court does take into account also that the defendant's position within the church and access to the youth play a factor in that, as it does in cases where there are children involved and certain behaviors, threats, if you will, enticements, other things can come into play. What is also of note, and something that the prosecutor brought up and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment was set at the $3 million, the current bond that it is set at, did not take into account the additional charges that came forth. So this is really, in essence, the first addressing of bond with the additional charges of the additional individuals. I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case.
This is the turning point. When Judge Simpson says there is a great presumption of guilt, that is a legal threshold. He's not declaring guilt, that happens at trial. But for bond purposes, he's saying the evidence presented so far is strong enough to shift the burden. Normally, bond hearings operate under a preponderance standard, more likely than not. But here, he explicitly says the burden shifts to clear and convincing evidence that the defendant is not a flight risk or danger. That's huge. The defense now has to overcome not just allegations, but a judicial finding that the evidence appears substantial. That changes everything. The courtroom energy shifts. The defense isn't arguing from neutral ground anymore. They're climbing uphill. And let's not miss this. The judge is careful. Like he keeps saying what has been laid out, and if the evidence bears that out. That's judicial discipline. He's anchoring everything to the record before him. Here's the real question. When a judge publicly states there's a strong presumption of guilt at the bond stage, how much psychological impact does that have on the rest of the case? On jurors down the road? On plea negotiations? This moment carries weight far beyond today's hearing.
I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't even want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically put into, these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals, and then these individuals don't come forth. As the proffer indicated, that was put forth by the people. If that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who is then that next day has to see that person in, well, places, a church, and that person being in a position of power or authority. Been doing this a long time. That whole concept may seem like it's just something that just happened. Frankly, when one looks at it on the surface, that it's actually, if this is a circumstance where the two incidents, that's all that I had necessarily before me, occurred, that's not by accident. That is, that whole series of things is by design for a very good reason, because that stops this person from saying anything, doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say so. In just listening to that, looking at what's been laid out by the people, the court, as it indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear, convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift, in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences.
Now we're in flight risk territory. When a defendant faces potential life sentences, courts take that extremely seriously in bond decisions. Why? Because the incentive to flee increases dramatically. The more severe the potential punishment, the stronger the motivation to disappear. Judge Simpson also highlights something subtle but powerful. The defendant allegedly left the state during an investigation, and even his parents didn't know where he was. That's not just travel, that's concealment. And concealment weighs heavily in flight risk analysis. But the defense counters. He came back. That's interesting. Voluntary return can mitigate flight concerns. But the judge's reasoning is clear. Connections in other states plus severity of charges equals heightened risk. But let me ask you this. If someone leaves during an investigation but later returns, does that show consciousness of guilt, or does it show they had nothing to hide? That's the kind of nuance jurors wrestle with later. Right now, the judge is calculating risk probabilities, and the math isn't favoring the defendant.
That also, there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parents or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that when the very fact that if he were going to flee, that he comes back under what circumstances and for whatever his reasons are of coming back. I don't know, and maybe that's to be told, but this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before, does pose a danger to the community.
This is the second pillar, danger to the community. Bond denial requires either extreme flight risk or clear danger. Here, Judge Simpson finds both. He mentions letters of support, people saying good things about the defendant and his family. That's common in cases involving respected community members. But then he references something chilling, the mother allegedly stating her son was leading a double life. That phrase matters. A double life suggests compartmentalization, public persona versus private conduct. And for a judge assessing danger, unpredictability is a red flag. If someone can maintain a positive public image while allegedly committing serious crimes, monitoring becomes extremely difficult. And listen carefully to what the judge says next. The court doesn't have the tools to adequately monitor and prevent harm if bond were granted. That's a practical concern. Electronic monitoring doesn't prevent grooming. Conditions of release don't eliminate access unless the defendant is fully removed from environments where harm could occur. So here's the hard question. When alleged harm involves psychological manipulation rather than public violence, how does a court realistically prevent it pre-trial? Judge Simpson answers that question by leaning toward absolute prevention, detention.
I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court, it was much, where in talking with the Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there is given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, the number of alleged victims, the court does not believe that the $3 million bond, which was initially set, is an appropriate bond. and that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied.
And there it is. Bond denied. This is one of the most consequential rulings a defendant can receive before trial. Judge Simpson doesn't just deny the motion to reduce bond, he grants the prosecution's motion to deny bond entirely. That means no amount of money secures release. The defendant remains in custody pending further proceedings. Notice how methodical the judge was leading up to this. He built a layered justification, strong presumption of guilt, credible pattern of grooming behavior, potential life sentences, increasing flight risk, connections in other states, and danger to the community combined with limited monitoring tools. This wasn't emotional, it was structured. Legally, this ruling signals the court believes the statutory requirements for denial have been met. That is rare. Courts are generally reluctant to fully deny bond unless the case meets very specific criteria. Now think about strategy moving forward. When bond is denied, pressure increases. Pretrial detention changes dynamics. Resources, stress, negotiation leverage. It also sends a message to alleged victims that the court is taking their claims seriously. Do you think bond denial strengthens the prosecution's position heading into preliminary examination? Or does it raise the stakes for the defense to dismantle probable cause as quickly as possible? This ruling reshapes the battlefield.
We are also set. Go ahead.
Thank you.
We are also set for PCC. Are we ready to proceed to the next stage in this matter, or we're
Judge, I was gonna ask the court, will you give me will you do a written motion on that order that you just made?
You mean a written order?
Yes, sir.
I usually do not prepare a written order. If you'd like to prepare one, you may, and I look at it and sign it. But I mean, in terms of, there'll be a written order denying his bond. But
No, I understand. I just wanted your written findings in the order that you put on the record.
I'm going to let the record stand. If you want to draft an order, counsel, I will be more than happy to look at it and sign an order if it's appropriate.
Okay. So as far as the PCC goes, again, we just got their supplement report yesterday, number 12, where the last one we were doing on the 9th, that I had asked the prosecutor specifically if there were any more warrants out. There was not. Apparently there are. There's Snapchat warrant number 1 and 2. Based on that report that I just got yesterday, there's Beth's phone. I don't know what that is. And then she's got also on there that the MacBook Pro, the black MacBook, and another phone. Apparently they're still doing some forensic stuff on that.
Now we pivot into discovery, and this is where cases like this often become battles of digital evidence. Defense counsel raises outstanding Snapchat warrants and forensic analysis of devices. In modern criminal cases, especially those involving allegations of communication with minors or grooming, digital evidence is central. Phones, laptops, messaging apps, these can make or break credibility. But here's the tension. The defense says they just received supplement report number 12 and are learning that additional warrants are still pending. That raises concerns about late arriving evidence. Discovery timing is critical. The defense must have adequate time to review, analyze, and potentially hire their own forensic experts. If Snapchat returns data the day before preliminary exam, that's a problem. The judge clarifies that the warrants have been served and they're waiting on returns. That means law enforcement is in the hands of third-party providers. And here's a question for you. In a digital age, should courts delay proceedings indefinitely waiting for forensic results that could take years? Or should cases move forward based on currently available evidence? Judge Simpson is clearly leaning toward moving this case forward.
I'm also going to address some of the older stuff that we previously asked for, which she alluded to today, I think, which is the wired conversation between
What conversation?
wired. I've looked through my stuff. She can direct me to a time or date stamp and a date for that particular conversation that was made between Priscilla and Mr. Radcliffe. I've looked through all my stuff.
Your first name, Priscilla, being
Bert.
all right. Go ahead. Oh, I got you. The X in him.
Yep. So there's apparently a conversation that was recorded that I don't have. I don't know if it's something that they've sent and it's in something else possibly, but I pretty much have gone through everything that has been sent and I have not seen that. And then we've also asked for the victim advocates notes, which were done by Megan Alameda. Whether they're exculpatory or inculpatory, doesn't matter. We're entitled to them. And we have a right to those notes. If any of the victims made statements to the victim advocate, I would ask for those notes. And I previously asked for that information.
So what I have here is I have two things: the wired communication and victims advocates notes. This one here.
Those two things, but also, Your Honor, are we going to get Snapchat warrants? That I thought warrants were no longer in play, but again, we just got the sub report 12 yesterday, which says that these are outstanding. The Snapchat warrant 1 and 2. So I didn't think that there was any more warrants out there for material. If they are, that's fine. I just, I thought that we had already answered those questions.
Mr. Raz.
We would ask that a preliminary exam date be set. I believe that we'll need a separate date because of the number of witnesses and the length of time that it will take. So I would request that it not be set on a Tuesday with other exams because of the number of victims that are set that will be testifying, I should say. The recording should have been sent, and I'll confirm with our discovery clerk if it went evidence.com or if it's something that counsel needs to pick up, but it is item 22. The recorded conversation between the defendant and one of the witnesses. So he should have it, and I'll double check. And
So you believe what's been referred to as the wired communication has been sent?
it should be. I don't know if it went on evidence.com. It's listed as item 22. So I have to check with Ms. Warnick because she sends everything out. I don't know if it was mailed on a DVD, but that should have already been
Gone too. Okay.
That's it. I don't believe, I don't have, and I don't believe that the victim advocate's notes are discoverable. So I would ask for some authority on that. I don't know how they would be relevant.
I don't know how they would be discoverable either. Do you have anything on that?
I don't have. I think I may have something, Your Honor, that I can forward. I could file something as a supplement.
That's fine. I mean, on first blush, I almost look at it as though it would be getting an attorney's office personnel notes regarding conversations that they have with clients. And it would seem to me on first blush, I'll give you an opportunity to get something to me, that's going to be privileged information and that wouldn't be released. So subject to getting anything else, that's going to be my ruling, that those notes that with regard to victims from the victims advocates would be privileged communications because of their contact with the prosecutor's office and their work product, which may be part of the prosecutor's office. So that's the theory that I'm operating, but certainly counsel, feel free to file whatever is necessary.
This is a subtle but significant legal ruling. Defense counsel requests victim advocate notes, arguing they're entitled to them whether exculpatory or inculpatory. The prosecution counters that they are not discoverable. Judge Simpson initially views them as potentially privileged, comparing them to attorney work product or internal communications within the prosecutor's office. Here's why this matters. Victim advocate communications often contain emotional disclosures, preparation discussions, or support interactions. If those notes are considered work product or privileged communications connected to the prosecutor's office, they are shielded. The defense, however, may argue Brady obligations. If something exculpatory is in those notes, it must be disclosed. So this becomes a legal tension between privilege and constitutional disclosure requirements. And think about this. If a victim advocate's notes contained inconsistencies compared to formal statements, should the defense have access? Or does confidentiality encourage victims to speak openly without fear their words become cross-examination ammunition? This is a recurring conflict in sexual misconduct cases. The judge signals his leaning, but leaves the door open for the defense to file supporting authority. Strategic pause. The defense will likely research case law.
I was a bit confusing at the last hearing because I wasn't sure what warrants we were talking about. But I guess counsel has just received another
No,
report or
supplement 12 is not a warrant. Supplement 12 is an interview with a witness about a conversation. Supplement 12, January 13th, 2025. A witness called to talk about disturbing comments that the defense father made. That's supplement 12. It has a journal, but it's barely a page long.
oh, hold on.
That
I'm not,
report was sent over there.
hold it, because I want to make sure we're talking about the same thing. Because when I listened to Mr. Thomas, it sounds to me like you were saying there was a warrant out. Information came back from that warrant.
Oh,
Created a
yeah.
report.
Forensic analysis of the defendant's devices. I don't know the time limit on that. If we don't have passcodes, we could.
No, I get that, but I want to make sure, folks, that in regard to number 12, that we're talking about the same thing. Because as I understand what Mr. Thomas is saying, and correct me if I'm wrong, Mr. Thomas, it seems to me he's saying that there was a warrant that was out, that warrant netted certain information that then was placed into some supplemental report, which was just produced.
Right. I think it's at the end of 12. I looked at it briefly. I know it said something about the Snapchat warrants were out. It's I think toward the end.
So the supplement 12 is maybe 2 paragraphs. It's a witness that called to talk about some disturbing comments that the defendant's father made at 125. Status open, the case is open, pending the CCU's forensic analysis of the defendant's devices. There is something they're trying to pull off Beth's phone and search warrants for Snapchat 1 and 2. So those are outstanding things that the police department is waiting on, if you will.
Got it. Okay. So that's how I get to the Snapchat and the best. Okay. Now I think I
The search warrants have been served and we're waiting on the return.
waiting on the returns. Got it. Okay. Now I think I understand. So there was a report generated. At the end of that report, it just lists what else is out there that everybody's waiting on.
Correct.
And that's where the snap. Okay. Now I see where we are. So do we have any indication of when that might happen?
No.
I thought that's what you were going to say. Okay. So with that, counsel, I mean, I can set a preliminary exam date and what comes through, and I'll entertain whatever comes at that moment, but I don't know what's gonna, I mean, I have no idea what's gonna come of that. But what's your preference in terms of?
I mean, I'm fine, Judge. I think that, I mean, what I don't want is to get hit at the last second with a piece of evidence that we didn't get a chance to look at or to scrutinize, or, obviously you would understand that. I mean, you work on a strategy and, and then all of a sudden somebody produces something.
No, I got you. And I guess what I can do is I can set a prelim date. I can then indicate that if something is there, then certainly I would allow you to make that argument where it would cause a problem for you, and I'll deal with it how I have to deal with it. But I think at this point we have to move this case along.
This is the court asserting control. Defense counsel expresses concern about being blindsided by last-minute evidence. The judge responds firmly. The case must move forward. He acknowledges that forensic analysis of devices could take a year or 2, but he makes it clear the court will not adjourn indefinitely waiting for digital extraction. That's a critical judicial philosophy. Criminal cases cannot sit in limbo because technology labs are backlogged. The Constitution guarantees a speedy trial, not a technologically perfect one. At the same time, Judge Simpson assures counsel he will not allow surprise evidence to create unfair disadvantage. That balance is key. Fairness without paralysis. Here's something to consider. In cases involving alleged digital grooming, how much weight should be placed on devices that may or may not yield evidence? If no incriminating messages are found, does that undermine the allegations? If incriminating material is found, does that fundamentally change the case? The preliminary exam will likely proceed based on testimony. Digital evidence may become supplemental, not foundational. The judge is drawing a line. Preparation is required, but delay is not automatic.
So I'd like to do that. With the understanding that the other forensic, the electronic, the devices may not be available at the time of.
I mean, as your honor knows, these devices, it could take 2 years for the computer crime lab to get into them. So we can't adjourn, but we could be adjourned for another year, another 2 years. I just
Not doing it.
don't have the time.
I would just ask the court, if, if it's not producing, they get it at the last minute. Either we're gonna get continuance or they're not.
Right, I mean, well, counsel, just so that you understand how I work, I'm not going to let anybody. I expect counsel to do their due diligence in terms of any evidence that comes for us. So I don't expect somebody to lay out a piece of evidence. I haven't had an opportunity to do that. But I would not, I think counsel should be very clear. My expectation is that whatever information has to be given to each side will be given in ample enough time where the other side can do what they need to do. If they don't, if you run into that situation, I will always hear one's argument about why I can't proceed if something has just come to you. You haven't had a full-blown opportunity to do that. I'm not going to do anything that puts anybody at a disadvantage.
This is Judge Simpson setting courtroom expectations, and he's doing it very clearly. He's drawing a line between legitimate discovery concerns and tactical delay. When he says he expects counsel to do their due diligence, that's a signal to both sides. No sandbagging, no holding back evidence for surprise impact. At the same time, he's reassuring the defense that if something truly last-minute surfaces, he will hear the argument. That's important for appellate purposes. A judge must demonstrate fairness and procedural balance. By stating on the record that he won't allow unfair disadvantage, he's insulating the process from claims of prejudice later. But let's look at the subtext. The court believes this case has enough substance right now to move forward. He is not waiting for perfect digital extraction. He is not waiting for every Snapchat return. So the focus shifts to testimony at the preliminary exam. That's where probable cause will either solidify or crack. Here's the engagement question. Do you think modern courts should pause major cases until every bite of digital evidence is processed? Or should witness testimony remain the primary engine at early stages? Judge Simpson clearly favors forward motion.
So when would we like to do this?
Do you have certain days that apparently you do them on Tuesdays, right?
Well, yes, but that's rotating. But what Ms. Reiser indicates is that it's going to have to be a special day. So it's going to come off of my very skimpy docket I have to give.
Well, and Tuesday there are several other cases that-
It's not going to be a Tuesday.
Judge, I don't know if you'll do this, but can we do it on a Friday? Is that a possibility for it? Just asking, only because.
No, I hear you. Okay, so just what my reluctance is I have housing dockets on Fridays, which are intense and very long. And when I put them over, that means the next following week is even longer. And are Mondays bad for you? Or
Just like any other lawyer, I mean, that's, I'm gonna have to make sure that I get everything cleared off my docket, on a Monday. I'm not overly worried about it, Judge, but
Okay, Mondays work better for the court. I can tell you that. Ms. Reiser, what about Mondays regarding you?
I could find a Monday.
All right. So if we work with Mondays, why is this at 11?
This is a trial. That was the Simpson.
you like the 20th,
Trials in the morning.
Do we have anything set?
February 24th?
Oh, February.
Think of something else.
We really shouldn't, but. Just, that's, yeah, okay. So I have available Mondays. I have February 24th, March 3rd, or the 10th, and whatever day I'll just clear out whatever else I have.
I am available February 24th.
February 24th. That's now the focal point. Once a preliminary examination date is set, the procedural clock tightens. The prosecution must organize witness order, evidence presentation, and argument for probable cause. The defense must prepare cross-examination designed not necessarily to win, but to probe weaknesses. And here's the nuance. The defense may not reveal its entire strategy at prelim. Sometimes counsel holds back impeachment material for trial. Other times, they aggressively attack credibility early to test the prosecution's foundation. Given the judge has already denied bond and articulated a great presumption of guilt for bond purposes, the preliminary exam becomes an opportunity for the defense to shift narrative momentum. Will testimony align perfectly with police reports? Will there be inconsistencies? Will cross-examination expose doubt? That's the stage that's coming. And here's a question for you. Do you think bond denial psychologically affects how a defense team approaches the preliminary exam? Does it increase urgency or strategic caution? February 24th becomes the next major battleground.
The 24th.
That work for it? Okay. Preliminary examination in person will be set February 24th, 2025, 9 a.m., and that is before me.
This hearing was about more than money. It was about risk assessment, legal thresholds, and the court's responsibility to balance constitutional rights with community protection. Judge Simpson denied bond after finding a great presumption of guilt for bond purposes, determining the defendant poses both a flight risk and a danger to the community, and concluding that available monitoring tools would be insufficient to prevent potential harm. He addressed discovery disputes, clarified expectations regarding evidence disclosure, and refused to delay the case indefinitely pending forensic returns. The preliminary examination is now set for February 24th, 2025. Legally, today's ruling signals that the court views the allegations as serious, structured, and supported by sufficient preliminary evidence. However, guilt has not been determined. And bainabikum mastram nastiya bahalit. That remains for trial, if the case is bound over after preliminary. The next stage will test witness credibility, evidentiary consistency, and prosecutorial foundation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.